Shepherd's Cove's free virtual webinar on getting your affairs in order, which we're conducting on April 16th, which is National Healthcare Decisions Day. I understand you may be listening to a recording of this webinar on another day, but I want to encourage you and applaud you for taking the time. It doesn't have to be National Healthcare Decisions Day. Any day is a great day to make important life decisions and plan ahead, bringing you peace of mind and giving a precious gift to your family in the years to come. I am Anna Grace Morgan with Shepherd's Cove, and I am pleased to introduce you to two of my friends. We are joined today by two leading experts in the area of end-of-life planning, Norma McCord-Wells and Laura Gibbons of Turning Point Legal in Guntersville, Alabama. Y'all say hi.
Hi.
Together, Norma and Laura work to serve clients throughout North Alabama in a caring and professional manner by implementing cutting-edge Medicaid planning and elder law strategies and techniques. Estate planning is an area of expertise and specialized knowledge for Turning Point Legal, and these two wonderful ladies have extensive experience helping clients with legal changes, guardianships, wills, deeds, and trusts, and they are just two of my favorite people who both serve on the Shepherd's Cove Planned Giving Council, and Norma has served on our board of directors for, goodness, how many years has it been, Norma?
9 or 10 years.
A lot of years. We'll sum it up to say a lot. So depending on the circumstances, of course, estate planning can be stressful and emotionally trying, but Turning Point Legal is a small firm that is always focused on giving you friendly service and personalized attention, and you will enjoy hearing from them so much today. Norma and Laura have both been providing sound, compassionate legal advice in regard to asset protection, estates, and more since 2002. So they give generously of their time and talents to make our world a better place. Laura, Norma, thank you so much for sharing your expertise with us today.
Thanks for having us. Yes.
And we're just getting used to a virtual format. So we're all new at this and we're all learning here together. We had hoped to be with you in person today for National Healthcare Decisions Day. But, you know, the coronavirus has changed a lot of things in our world, and this is certainly one of them. So, of course, National Healthcare Decisions Day has been celebrated the day after tax day for the past 12 years. It's usually a pretty good day to discuss someone's wishes. But, you know, again, now we're altering the way that we live because of this coronavirus, and the focus on advanced care planning has really taken on a new meaning for a lot of people. Shepherd's Cove Hospice wants to acknowledge National Healthcare Decisions Day by stressing the importance of having potentially difficult conversations with your loved ones about your healthcare wishes and documenting those by completing an advance directive. In fact, we are offering an opportunity to get that done with a free document review and virtual signing day next week on April 23rd. And that's going to be from 11 to 1, and you can sign up for a 30-minute review or consult with one of our compassionate planned giving council professionals. So you will also find a link on our website. It's www.shepherdscove.org/document review down there. You can see on your screen. You can find some helpful information there from the National Hospice and Palliative Care Organization. They've got all kinds of resources for you. And of course, Shepherd's Cove is proud to be a member of NHPCO, which is an organization that enhances and expands access to care and addresses holistic health and well-being of communities across the country. So if you aren't familiar with us at Shepherd's Cove, we are the oldest, largest community-supported hospice located in Albertville, Alabama, and we have one of only 4 freestanding inpatient hospice facilities in the state. We are more than just hospice, and we exist really to relieve suffering and create those life-changing experiences for grieving families in our communities. And we do that through a variety of different organizations. We actually have 3 different organizations under the Shepherd's Cove brand: Shepherd's Cove Hospice Foundation and the Palliative Care Organization. We also have a thrift shop, and we are so fortunate to have a great grief support services and Camp Hope. And of course, ways for you to volunteer and get involved, putting your compassion into action. So if that's ever anything you're interested in learning more about, if you're interested, just get in touch with us. We would love to have a chance to work with you and help you, again, be the change that you want to see in the world and implement that. So it's our mission to provide with a servant's heart, exceptional, individualized care for those who are coping with end-of-life issues. And that's exactly why we are here today. Obviously, given the uncertainty that we find ourselves coping with the COVID crisis, it's just never been a more important time to talk about the care that you would want or would not want with your loved ones. And it's a worthwhile activity for all of us to undertake. And we don't want to put it off any longer. I know, working in the end-of-life care industry, we see it all the time, that there's fewer than 1 in 4 people who have even the most basic of documents prepared for their end of their life. We just don't like to think about it. And so we're here today, to learn more about how we can get our affairs in order. So I'm going to turn it over to our experts. I say in the room. It's so hard for me not to say that, but y'all are sort of in the room. But Norma and Laura, thank you again for being with us today and helping us to learn more about how to get our affairs in order.
Anna Grace, thank you so much. I'm Laura Givens, and as you know, this is Norma Wells. We are in a virtual room together. And
trying to practice social distancing, but it's kind of hard to get on the screen 6 feet apart.
Right. And we are still open. We have our waiting room actually closed to the public. People who come in can only come by appointment right now due to COVID-19. But we are now able to have documents signed virtually as well. That is something new. That's something that the governor signed in because of dealing with this crisis. So I'm going to just outline what we're going to be discussing. It's estate planning documents that each of us should have in our own arsenal to deal with medical emergencies, financial emergencies. If we're unable to get to the bank, then someone else may be able to go there for us, and that would be powers of attorney. I'm going to discuss what an estate is, whether you feel like you have an estate or not. You don't have to be a millionaire to have an estate. We're going to discuss last will and testaments, trusts, and those we're just breezing over. And then we're going to discuss a power of attorney and what the benefits of a power of attorney and advance directives. Anna Grace, at hospice, I'm sure you see that powers of attorney and advance directives are very important.
Yes, absolutely. Every day.
So the definition of an estate. What is an estate? It's any interest in any property that you may own. So if you own your home, you own real property, land, any of that, and any personal property, money in the bank, anything like that, that is your estate. Again, you don't have to be a millionaire to have an estate. You should plan ahead to protect your estate and make sure that it provides for your spouse and children. This will ensure to avoid family conflicts. If you have a child or even a spouse with special needs, meaning some sort of disability, that they may be receiving some government assistance, such as Medicaid for health benefits, then you need to make specific plans for them. If you don't plan properly for them, they could end up having issues with those benefits after you pass. And it's also to make sure that you can leave a lasting legacy. So what documents should you have at the minimum? The last will and testament. And you should also have a contingency in there for a special needs trust. Don't go to online sources. See an attorney about this. These are very important documents. Durable power of attorney. Same thing. Please see an attorney when you have those done. I know there's forms online, but we often are dealing with having to go to court to help fix those documents. Advanced Healthcare Directive and a HIPAA authorization, which we have incorporated within our Advanced Healthcare Directive. Norma's going to be delving into those very well. Okay, so Norma, do you want to talk about last will and testaments?
A last will and testament is a written document that's signed. There are certain ways and certain things that have to be incorporated in the signature portion of your will to make it a valid, self-proving will, meaning your witnesses don't have to show up to court after you've passed away and those kind of things. What the will is for is to say what you want to happen to your belongings after passing. Alabama requires 2 witnesses on your will. Most states require 2 and a notary. Louisiana requires 3. 3 different people to sign.
Yeah.
So anyway, but a lot of people, as Laura was saying, will come in at the last minute. They've written up some sort of will on notebook paper and carried it down to the bank. We had the nice lady at the bank notarize it for them. That doesn't necessarily get the job done. It certainly explains what they want, but as far as being valid for probate, most likely it's not. And those kind of things cause a lot of problems when your loved ones get to that point. So a lot of the reason we preach about doing these documents ahead of time is so you don't leave your loved ones with a big mess to clear up once either you can't fix it for yourself or you passed away. The will nominates who you want to be your executor or executrix. It can nominate guardians for minor children, so don't think, well, I'm 30 years old, I don't need a will. If you have minor children, that way you can direct who you want to have custody of those minor children if both parents have passed away. You can determine how your property is distributed once you've passed. If you have a taxable estate, you can make determinations regarding that, or perhaps make tax planning moves in your will that take care of those things for your loved ones when your time comes. The will, to be effective, has to be probated after you pass away. They are not recorded before you pass away. We get that question frequently. When do we record our will? Not till you're gone.
Oh, hey, and Anna Grace, will you go to the next slide?
Yes, ma'am.
Let me just interject here. There is not a will reading party. That can happen if someone wants us to do that. I've done that once or twice to appease everybody, but that's the movies. So that's Hollywood. What we generally do is whoever has actual control of the will, don't hide the will from the other beneficiaries. Let them know what the will says. Go ahead. Anyways, I just wanted to interject some personal.
Oh yeah, it's usually those you leave behind. If the family has some clue of what's about to happen in your will, if you really want to do something that you know loved ones are not going to like, and leave your executor or executrix to deal with it, at least give them a heads up so they kind of can prepare ahead for the storm that's to come later.
But then don't hide it. Go ahead and give them all a copy of it. Let them know if they were disinherited, they're going to find out sooner or later. If you wait for a court to force you to give it to them, then all it's done is caused emotional strain in the family.
Can I ask a question? So one thing we see often, or that we hear from a lot of our families, is I only have one child, she should just automatically get everything. Can you address that for the folks who might be listening? Do you still need a will if you only have one heir, if you will?
I hate to say you don't have to, but it may.
The only benefit would be if you have real estate.
That's where I was headed.
Yeah. Then, because I'm the real estate queen here. I do the real estate. So if you have real estate, it reduces down the time period for the claims period, and helps give the person authority to sell real estate without getting a court order. It allows for you to be named that person in charge to handle the real estate without having to get a bond. It makes it less expensive.
After you pass away. Now, if you choose not to do a will, or you get in too bad a shape to do one, the lovely state of Alabama and all states do have a plan for you. It's called the Laws of Intestacy, and in them they prescribe what your assuming you have a surviving spouse, what the surviving spouse is going to get under different circumstances, like whether or not they're the first spouse and parent of your co-parent of your children, or if it's a second, third, fourth, ever how many spouse down the road, what they would get, and then what goes to your actual biological children. Also, and for blended families, this may or may not be a big deal. If you pass away with no will, but you have an agreement between your spouse that y'all are going to divide the estate equally, and whichever one of you passes first, then what's left, or second, whatever's left is to be split between his children and her children. It ain't gonna work that way if you don't have a will, because under the laws of intestacy, it is only your blood kin or your adopted children, legally adopted children, that count as far as the laws of intestacy. If you really intend those stepchildren to take whatever portion after passing, you have to have a will to actually specifically name them and include them.
Right.
So,
And so did that answer your question, Anna Grace?
Yes, I think so. Thank you.
Okay. So the will is a public process, and that we need to stress that. So if there are things you want to keep private, you may want to set up a trust that is a standalone trust agreement that you make with the trustee. And if this is a revocable trust, you are easily the trustee and the settlor. And if you'll go to the next slide, Anna Grace. The trustee is the person who manages the assets that are placed into the trust. So if you have a revocable trust, this revocable trust is a great tool to deal with your property in the event you become incapacitated or when you die, to allow the trustee, and it could be that you were the trustee, but you die, then this alternate is named, and that would be the same person that you had as your personal representative or your executor in your will. And they don't have to go to court to get permission to handle things. They can disperse out and distribute according to the terms of your trust, and it's private. Other than a certificate of trust that may get recorded in the probate office, it is not something that has to be shown and filed with the probate court. You can have more than one beneficiary. It can be written or oral. I do not advise to have an oral trust. Obviously, I'm an attorney, and I'm going to say write it down, even if you're writing it on a napkin. Please put it in writing. And you can have trust protector language within that. That is a great tool that we often use, so that the trust protector can make some changes to the trust to ensure your intent is followed in case the law has changed or there's some other protection that needs to happen. I've used it for beneficiaries. I've written all different trust protector abilities.
Beneficiary changes, you can use it, for example, like when I said for law changes, we just had recently, I just had some law changes where it involves IRAs that are left to a trust. We can help with those. That's sometimes, but
we need to deal with that right now.
We can help with those. This is irrevocable. You're kind of stuck with what you did 5 years ago, 10 years ago, unless you have this trust protector provision in there. Say that 3 times fast. Trust protector provision in there to allow someone to kind of come in behind you and fix those things.
Right. We, both Norma and I, do a lot of irrevocable trust, and that is more getting into the either asset protection in long-term care planning, or in the need for special needs trust planning and for that disabled child. And we often make those as irrevocable as well, so that the benefits that the beneficiary may have can continue. Okay. So that leads into special needs trusts, which are also called supplemental needs trusts. It doesn't really matter what you call them, as long as the specific information is within that trust. It protects that disabled beneficiary's eligibility for benefits. So if they're receiving Medicaid for their health insurance and it's paying for their prescription drugs of thousands of dollars, sometimes a month, it ensures that they continue with those benefits. It provides for a higher quality of life. Often, if someone has entered the nursing home, if they have not set aside some money, and we often use Alabama Family Trust, which is a pooled special needs trust, if they set money aside in there, they have the ability of having a private room while they're at the nursing home, or things that their health insurance would not otherwise cover. It provides for a framework for care and management of their assets, and it ensures that it extends their life of assets. So they have those benefits of those assets during their lifetime. Now, I could do a whole seminar on special needs trust. There's what's called first party special needs trust and third party special needs trust. And those are all things, it depends. If you've done the proper planning for your beneficiary in your estate planning documents, you will ensure that they are the best special needs trusts, which are third party special needs trusts. If you do not do the proper planning, your beneficiary may end up with a first party, which means after they are gone, whatever money that they have not used in that trust then is paid to the state of Alabama. So it's best to do planning. Again, don't try to go to the internet and figure this stuff out. See an attorney that is experienced in this area and get some good advice and some good documents, and actually have them help you with funding the trust and things like that. Okay, you're doing powers of attorney?
I'm doing powers of attorney. Now we're shifting gears. So if you want to flip the slide in, Grace. Powers of attorney. Most everybody is familiar with a power of attorney. The Alabama law changed a few years ago where we don't have to call them durable anymore. They are automatically durable unless you specify otherwise in your document. But everybody still calls them that.
And Anna Grace, we have a friend, a good friend, Marty, who lives in Maine, and he had given us these slides, and I apologize, but I had thought I had gone through and fixed certain things in there, but there's two places where I see his lovely state of Maine popping up, which is the same, it has the same rules as Alabama. So I just wanted to make sure that that was pointed out as an error that we.
Oh, good. Maine, Alabama. This could be,
hey,
who knows?
It's
folks
from
may
one
be
end
watching
of the,
in Maine.
one end of the United States to the other. We're practicing social distancing, talking to you from Maine. No.
Yeah, exactly. Yes.
Videos now, as opposed to, it makes our universe much smaller, right?
It does. Absolutely. All good. No worries.
Okay. Well, anyway, powers of attorney enable your agent, whoever that person might be, to act on your behalf, with whether in financial transactions, making decisions for your health care, dealing with your stuff. Depending on how much authority you give in this document, your agent and a power of attorney can deal with your property just like you could if you were standing there. Which brings us to my soapbox issue of choose carefully. Please choose carefully. Don't just choose your oldest child because they're the oldest child and you feel like you should. That child may be great and may be the one you need to pick. But if that child has been in bankruptcy 2 or 3 times or has a criminal record, and your younger child is like a stand-up, manages their financials well, manages their life well, but think about that real hard before you choose your oldest child.
And you don't necessarily have to choose a child. If you don't have a child you can trust, hopefully you have someone else in your life that you feel that you can trust to put in this fiduciary responsibility role.
Yeah, absolutely. Because basically, I hate to make biblical references because I'm afraid I'll make it wrong, but you hear about people talking about turning over the keys to the kingdom. Whoever you name as your agent, you are turning over the keys to your kingdom to that person. So choose wisely, and you don't have to choose the same person for your financial business as you do for your medical business. So if you have one child who is a CPA, obviously you would think they would be an excellent choice for the financial side. But if your other child is a nurse, that child might be better suited to be your medical power of attorney just because of their different expertise. So you consider your situation, consider your loved ones, consider your friends in making these choices. So you choose the best person who will do what you would have done in that same situation if possible.
And one thing in that slide back there, it had something about springing. Some people really want to have springing. I advise my clients, if at all possible, if you have someone you trust, go ahead and make it right now, immediate. Don't require them to run around to doctors to get letters saying you are incapacitated to make it an effective document. You should not be appointing them as your agent if you don't trust them to not use it unless in certain events that you've required them to use it in.
And so often when somebody needs to use your power of attorney, they need to use it right now. They don't have time to go to, Dr. So-and-so, especially now in this time of COVID-19 where you're doing the telehealth thing and the doctor doesn't feel like he or she has authority to talk to this strange person that they don't know. Anyhow, it becomes a conundrum for whoever you named as your agent. Let's see.
So you can go back. Now you can go forward.
Yeah.
Thanks, Grace.
Yeah.
She's our PowerPoint person.
Yeah.
Quick. You go ahead.
Oh, okay. And moving on to other important documents, the Advanced Healthcare Directive, which is part of what got us here today anyway, since this is National Healthcare Directives Day. There is a healthcare power of attorney, and then there's an advanced directive. And in Alabama, those are two different documents. The advanced directive is what everybody kind of knows as a living will, and that is for making end-of-life decisions when you are not in any shape to make those decisions for yourself. Basically, you have to be almost at death's door for your advanced directive and living will to come into play, because it gives whoever you name as your healthcare proxy in that document basically the authority to act on your wishes of whether you would or would not want life-sustaining treatment if you are permanently unconscious or terminally ill with no hopes of recovery, and you're to the point where the doctors are looking at the family going, y'all, we've done all we can, what do you want us to do? And the advanced directive allows your wishes to be known and your wishes to be followed instead of leaving it up to chance or leaving it up to your family who may know what your wishes are but not have the intestinal fortitude to follow them, whichever way that might turn out, or leaving it up to your family where one child wants every possible measure there is taken and the other child's like, no, that's not what mama would have wanted, and having them have that big fight and leaving them with lasting hard feelings toward one another because they couldn't get it together, after passing. Healthcare power of attorney will allow someone to make healthcare decisions on your behalf before you get to that end of life moment. It allows someone to get into your healthcare records, to have access to those, make those HIPAA, get that HIPAA information that's so protected now. If the power of attorney is correctly drafted, it will allow your agent to make decisions for you, such as, do you get a flu shot this year? Are you getting the proper treatment? If I, as your agent, don't think you're getting the proper treatment from Dr. A over here, I can fire Dr. A and bring Dr. B in, who I feel like is going to do a better job.
You can go to the next slide on HIPAA authorization. Awesome.
Oh,
there we go.
Circling back to the HIPAA authorization. Sorry, I'm getting ahead of myself.
No, I think you actually covered everything on there. Yeah.
With HIPAA authorization, and I know, Anna Grace, y'all see this over at Shepherd's Cove frequently, if a patient is not able to execute a HIPAA authorization, it kind of becomes a conundrum if they haven't done it ahead of time. Who can we talk to? Who's the caregiver? Who can we give this protected information to? And all medical providers have that same issue. It has really become a big deal since all the HIPAA laws have been passed.
And really, please try not to write that out on a napkin. This is so important. Hospitals, probably hospice. There's a form that the state puts out, and all hospitals have a little booklet that kind of explain what it is, and you can go through and do it. Don't just try to handwrite one.
y'all do that. As far as the advance directive itself for the very end of life decisions, Anna Grace, doesn't Shepherd's Cove have one of those on their website?
Yes, I believe so. And I know that we have links on that shepherdscove.org where we are talking about our event that's coming up next week, the virtual signing day. We have links to advanced healthcare directives as well as all of the stuff, all of the things, all of these authorizations that you'll need for healthcare planning. Yes.
Right. And certainly one of mine and Laura's biggest goals of today is to make sure that folks understand what these documents are and what provides what authority, and puts at least a little bug in your ear of choose wisely who you're going to give this authority to, because it may not seem like a huge deal when you're drafting the documents, but when push comes to shove and you really need that person, it's not a prize, it's not a knee-jerk thing, it's something you really need to have thought about and given to the person most suited to do whatever it is you need done or you want done, not somebody's going to flake out on you in your time of need.
And if your kids don't get along and that's who you want to appoint, don't appoint them all together. Because if they don't get along, they're not going to work together on these things. It's serious matters. We need to have one person in charge who will direct what your wishes are.
Yep.
The slide right now that Anna Grace has up says, how will your healthcare providers know that you have these documents? Once again, that goes back to make sure you put someone you trust in charge, because seriously, if your healthcare proxy you named in your living will, your advance directive, totally disagrees with what your wishes are, they can just put that document up and hide it and not tell a soul. And who knew had this, So choose wisely.
Yeah, choose wisely. And then there are some services. We actually use legal directives for our clients, where we will, if they want to sign up, there's a form that's filled out in our office, and we fax that over to legal directives along with the documents. And they will have them available 24/7. So if then what happens is you get a little card that you carry in your driver's license, with your driver's license in your wallet. If you are in a wreck, and they will find that card and they can contact then legal directives 24 hours a day, 7 days a week, have it faxed over or however sent over to the hospital where you may be. There's also DocuBank that has that service. I do think that some financial planners have started having that service available too, but I can't name that. So just inquire about that, because especially if you're someone that travels. I know a lot of people are probably not traveling right now. Both Norma and I have been forced to cancel short little vacations we had planned a few weeks ago. And that's probably going to be extended out a while where people aren't traveling. But when you start traveling again, you may want to have that in your billfold.
Absolutely.
Circling around to the comprehensive overview, we recommend that you do a last will and testament. That can be as complicated or as simple as you would want it to be, just as long as you express your wishes. If you are more interested in control, or you have asset protection questions or issues that you need to take care of, you may or may not need to go ahead and jump out there and do a trust. Certainly that's something that any estate planning or elder law attorney can discuss with you further based on your particular situation.
If you'll flip to the next slide, it shows what we should have at the very minimum.
So
That's what she was going.
Oh, well, yeah, that's what I'm heading through. Have a durable power of attorney, have an advanced healthcare directive. Like I said earlier, the great state of Alabama has an estate plan for you if you fail to do a will. It may not be what you want, but there is one, worst case scenario. But if you're living and you need some of these decisions made or some of these things done that you could take care of at your leisure, so to speak, in a healthcare directive or a power of attorney, do it then, because if you don't do it, and we see this frequently, and I'm sure Hannah Grace has seen it many times too, someone gets terribly sick, they can't take care of their financial business, they can't make healthcare decisions because they're just not able anymore for whatever reason, and DHR may or may not have to get involved. Someone winds up having to go to court to get appointed as this person's guardian and or this person's conservator without going into all that. Just
no, it's an expensive process.
It's an expensive process. It takes a little while, and like I said a while ago, a lot of times when you need these decisions made, you don't have that kind of time to wait. So if you have these documents in place ahead of time while you're not sick, you're just thinking ahead, making preparations for your loved ones so it's not so difficult for them to help you when you need it the most, everybody will be much happier and much better off, and you will be much better taken care of if and when your time comes.
Yeah.
Okay. Well, so that is a comprehensive overview and a reminder of what all we need to have in place, things we need to do today, not wait another day, whether today you're listening and it is April 16th, Healthcare Decisions Day, or it's any other day. Like I said, it's always a great day if you've not done these documents to get them done. So as a reminder, thank you so much, Laura and Norma, for being with us today. Thank you, Turning Point Legal. You guys are just awesome. Big round of applause for your
We love Shepherd's Cove. We think you guys are awesome.
Oh, absolutely.
We all are awesome. We couldn't do it without you, and we just appreciate you helping us know what we need to do to get our affairs in order, and I hope that everyone will. So everybody stay safe, stay healthy. Let us know if there's ever anything we can do to help you, and we'll see you next time. Don't forget, you can get registered for that event on April 23rd. You just visit www.shepherdscove.org, and you can sign up for a 30-minute consult with either Norma or Laura or our financial planners. We have a couple of financial planning professionals who are willing to help with more financial detailed questions or review those documents, your life insurance, make sure your beneficiaries are correct, things like that. So we have a variety of professionals in our Planned Giving Council who are on hand, who will be on hand to help you out. Like I said, you can sign up for a slot. We'll be doing those meetings virtually as well. So from the comfort of your own home or office, as long as you have an internet connection or a phone, you'll be able to make those calls. If you want to do the virtual signings, you will have to have an internet connection, one with a camera and microphone and all of that. But we appreciate you, Norma and Laura, again, so much for sharing your expertise today. And again, stay healthy and safe. We'll see you next time.